Good morning.
Good morning.
Okay, I'll just start the register. I see Leah Lowe,
Yes, ma'am.
Janice Stubbs, Alicia
Yes.
Wilson, Melissa
Yes,
Franz, and Siobhan Kelly, right?
Yep.
Thank you. How y'all doing today?
Pretty good.
Good. Okay, so just a little quick recap because we have a big chapter to go through. What are the fundamentals of corporate record keeping? Why we keep them?
One of the things to make sure we meet the compliance regulations, like statutory, legal, regulatory compliance listings.
Mm-hmm.
To also have them on hand in case the shareholders wants to take a look at them, review them.
Right. Anything else?
I have documented evidence of information about the shareholders, directors and officers and decisions that are made of things that the company actually does.
Okay, so in our covering those, you think we need their passport? Or some ID?
Yeah,
Okay, what about their address? How will verify their address?
there's some form of address verification document, maybe like a utility bill in their name,
Right.
property conveyance, something like that.
We need anything else on there?
Probably information regarding their source of wealth, how they make their money, their business activities.
So you may want a bank reference then.
Yeah,
Okay. What is the timeline we should file our officers and directors in?
within 14 days of appointment?
Okay.
To file it with the registry?
Isn't it the 14 days within appointment? That's not it?
No, I think the 14 days is if they change the registered office, the address of the registered office, so 90 days.
Okay.
No, what is 90 days? 90 days is something else. When we have to file it to the Registrar General's Department. Section 11 tells us this in the IBC Amendment Act.
Twelve months.
Right, but in 12 months, we have to do that. If I'm a shareholder and I want to see the books, how long you have to, before you comply with my request? How long
That
you,
one is 90 days.
yes,
90 days.
that's the one, that's 90 days there. What should, where does the registered office have to be in the Bahamas
Yes.
for an IBCA? What about the registered agent?
Yes.
The registered agent has to be in the Bahamas. And anyone could be a registered agent?
No, you have to be a a financial and corporate service provider.
So you have to be licensed then under the act,
Yes.
or,
Or a licensed bank and trust company.
yes. So you could be either or. Now, if I have a charge against the company as a creditor, what I can ask them to do?
We could submit that listing to the registrar for filing.
What that listing is?
It's just a register that contains mortgages or charges that the company holds.
Excellent. And the company could choose whether or not they want to file that, but if I'm a creditor, what I'll ask them to do?
To keep it on file, at least. at the
And
registered
ensure that
office.
it's filed with the registrar, right? Because I want the world to know I have a charge against you.
Yes.
Yes. Now, what about the accounting records? What is required for the registered office to do to say anything about accounting records for an IBC?
They have to have a declaration from the directors to say that it would be made available on request.
Mm-hmm. And the company is doing what? They're keeping the
And that they're actually keeping them.
reliable accounting
Okay.
records, eh?
Yes.
What should be kept at the registered office?
A copy of the seal, an imprint of the seal, or the actual seal itself.
Mm-hmm.
All of the file records, all the stuff we were just talking about.
Mm-hmm. What about the memo and art? And any amendments? We need that?
Yes, all of the governing documents, registers, minutes, KYC documents.
So in a trust, what you think we need to know, we need to keep for our own records as a form of record keeping for trust? What do you think we should have?
The deed, the trustee.
Mm-hmm.
A similar KYC on the settler and the beneficiaries to an extent, I guess.
Right.
Trustee minutes.
Uh-huh. Any financial records?
Hmm.
Yes.
And what else we should know?
Who has
From our-
powers?
Yes, who has the powers, who can make decisions, etc., who could remove the trustee, who can appoint trustees, all of that stuff, eh? Okay, so that's our quick recap of Unit 5. Any questions on Unit 5 or be a little clearer?
I actually have a specific question from Unit
Okay.
5, talking about the declaration and the filing of the declarations. Has there been any amendment to the original, is it the Accounting Records Act regarding that? And the reason I ask is because recently there was a situation where at the firm that I work, we were told that we needed to file that annually, but the actual act just says that you file it if you change registered office and agent and at the inception of the company. So I was just curious because I couldn't find any amendments, but that was pretty much like an
You know, I
auditing
think
firm.
they were unclear from they put that in because you see, it doesn't say about filing it. It says more or less that the registered office should have a note that it is. So if someone were to ask you, you have it on your file. But you see, it's been some confusion as to whether or not, because I mean, they had it that at the beginning of each year, they thought that it should have been filed. Because I guess accounting records are annually. But I'm thinking that that's something in-house. I don't know that that's an administrative function that's supposed to be happening at the Registrar's General's department.
Okay, that was a similar discussion we had because it came actually from an audit team that we have it on file, but they're like, no, it should be filed at the registrar every year. And we're like, and the act doesn't really say that, but
Right,
I
so,
was
so basically the IBC Accounting Records Act, eh? The
Yeah,
accounting
right.
records order, so you'd have to say based on that, we'll look at it some more to see, but so you'll have a definite answer, but as far as I was concerned, it's supposed to be at the registered office.
Okay, I was just
Because it's
curious.
supposed to be a declaration, a company shall keep at its registered office a declaration stating the company is maintaining reliable records and the county record should be made available to its registered agent.
Okay,
So they had a 2013 act. So
Okay.
you're supposed to submit it to the registrar initially.
right. And then if it was if it was something that was established before the act came into place, you had to submit it then.
Then you'd have to do it within 90 days of the registration of the company. If it changes its registered agent, you will provide the new registered agent and a declaration. Because it's only that the registered agent is declaring that they have these records.
Okay,
And that seems to be only once.
right.
I don't see it saying you have to do it every year.
Okay,
Because
Thank
even
you.
the 2016 Act only says you do it once and that's it. You keep in reliable accounting records, and only if you now change registered agent, you would have to now state that again.
okay,
Because they
Thank
just
you.
want the registered agent to be responsible. So you could point them to the International Business Companies Accounting Records Order,
okay,
and that will clear that up.
okay, thanks.
All righty. All right, so let's move on to Unit 6. No more questions, right? No? Okay. So in the client due diligence requirements, we now have to understand the legal requirements for client verification and due diligence, develop an awareness of the money laundering and terrorist financing risk inherent in the vulnerabilities of products and services relating to companies, gain an appreciation of best practices relating to client due diligence, apply best practices to client acceptance and monitoring policies and procedures, and assess and manage the client acceptance process for client compliance with applicable laws and regulations. Okay. Let's get started. Who's gonna get us started?
I can start.
Thank you. And I will make a note, I think, Lavette Bethel and Deandra Hutchison has joined us, right?
Okay.
Yes, ma'am. Good
Yes,
morning.
ma'am.
Good morning, okay.
Good
thank you.
morning.
Okay,
Hey.
let's go on.
So Unit 6, page 59, definition of money laundering. Money laundering is defined as the process by which criminals attempt to conceal the true origin and ownership of the proceeds of their criminal activities. If undertaken successfully, money laundering allows launderers to maintain control over those proceeds and ultimately to provide a legitimate cover for their source of income. The primary objective of the money launderer is to disguise the source of criminally derived property so that it cannot be attributed to the original criminal activity or activities of the launderer. In order to achieve this primary objective, criminals seek to disguise their own identity, conceal their ownership of criminally derived property, and conceal the fact that they manage and control criminally derived property.
Okay, so you see money laundering, that could indict a lot of people, eh?
Mhm.
So, you know, a lot of people they want companies, they don't want their name out there. They may not be criminals. They just don't want it to be known that they have interest in this or the other. So they usually use the companies for anonymity. But in this instance, I think the clients use the companies to hold trusts and thus to divest themselves of their assets for protection of their wealth. So it's, I don't want to work so hard all my years and somebody can just come and take everything that I've worked for in one fell swoop. I may make a mistake in my business affairs. I may fall short on my loans or whatever, and everything I worked for would have been erased. So I'm 50 years in and now they've taken everything I've worked for the last 30 years. So it's more protection and for succession planning. So you'd use the companies now as a holding for your assets and the trust owns the company. So in that instance, we'll say they're disguised, who is the owner,
Right.
but it's not for that purpose. So in this instance, they're more or less criminal activities they're involved in. Now, you may have some people who may have settled trusts that may have taken funds from criminal activities and they would now try to divest themselves of it. But it's up to you in your what you're going to do to ensure that this doesn't happen. But processes will help you with this.
KYC and due diligence.
Yes. So when you would have carried out your source of fund, how you get your monies, and you can, red flags will come up if they did not get it from legitimate sources, or they can't show you how they would have arrived at this point. And you would see evasiveness in some people, so you would know, well, I don't think we're comfortable taking you on as a client at this time. And then you don't want them to say they want to maintain control unless it's properly set out that they can now maintain control, and that what they will do, how they'll maintain control, how they'll be in control. They'll be what? For a company, what they may be. In order to control the company, who you have to be?
A director.
Yeah, so they may want to be directors in the trust, but they would want to be.
A protector.
Right, so they may want to maintain, so you have to be careful and see what the objective is, why they're setting up, what they want to do, what they're trying to achieve, and ensure that you're not facilitating any criminal activity, eh? So you just want them to provide legitimate source of income, how they would have attained their income, and ensure that you don't, you're not facilitating any crimes. Go ahead.
Okay, the 3 stages of money laundering. 1, placement. Placement is the physical disposal of the cash proceeds which have been received from the illegal activity into the financial system. 2, layering. That's separating illicit proceeds from their source by creating complex layers of financial transactions designed to disguise the true identity of the source of funds. 3, integration. The provision of apparent legitimacy to criminally derived wealth. If the layering stage has been a success, the illegally obtained fund will now be integrated into the financial system and appear to be the legitimate funds.
Okay, so we had instances before they would have brought the Gaming Act into play, where we had persons who would have been proprietors of these establishments, their monies couldn't go into the bank. Yes. So they would now have to find legitimate sources in order for their funds to now be accepted by the bank. What do you think they could do to do that, to legitimize their funds? What they would have done?
Open smaller businesses and funnel the money through his income.
So you
Buy property.
Right, property, they make sure they get properties. And so now you can get rental income from properties. So that's a legitimate source. They would open businesses that have heavy cash flow. So you'd have a small little, you have a shop that can generate that kind of business that now legitimizes your money, but if the money is pretty big, you need a lot of things going on, eh? But to try through, so first of all, they wanted to physically dispose of the cash by placing it into the financial system. And then they would want to layer it by separating the proceeds from their source by creating complex layers of financial transactions designed to disguise the true identity of the source of funds. And then you can integrate the provision of apparent legitimacy to criminally derived wealth. So if the layering stage has been a success, so you see how it works, you place it, you layer it, and then you integrate it. So you see that example shows you these 3 stages.
Right.
That will help you to remember the 3 stages, you think?
Very much.
Yeah, so now you could use an example. So usually if you can use a practical example that you're familiar with, then these things become easier for you to remember what they're trying to show you, how the 3 stages of money laundering work. So when you integrate it now, it's in the system and you have full access to it. And it appears to be legitimate funds. So you see a lot of people, you see properties just buy up. The small person can't really get properties because of how the prices have been inflated, because these people were able to purchase property because of the source of wealth they had. And now their funds are legitimate. They want to be recognized as legitimate business persons, eh? So we have placement, layering, and integration. That's the 3 stages of money laundering. Any questions?
Not this time.
We good?
Yes, ma'am.
Yes.
Okay, let's go ahead.
The commission of all the 3 stages of money laundering is not necessary for an individual to be prosecuted for the offense of money laundering, nor necessary to prove that a specific offense has been committed by any person. Knowledge, suspicion, intent, or purpose may be inferred from objective factual circumstances that the source of the launderer's funds have been criminally derived, and/or he has participated in any one or all of the stages of the money laundering process.
So we don't have to go through the 3 stages. We just need to find out that one has happened, and now we can say this whole situation is a product of money laundering, eh? So
Right.
from you try to put the illegal funds into the financial system, you are now what? Facilitating, or you are participating in money laundering, eh?
Right.
Go ahead.
It is important that a financial institution consider the money laundering risks posed by its products and services, particularly where those products and services are vulnerable to being used in the layering and integration stages of the money laundering process. The Proceeds of Crime Act 2018 defines what is an identified risk offense under the Act. That is corruption, cybercrime, human trafficking, money laundering, or financing of proliferation of weapons of mass destruction, terrorism or financing of terrorism, or such other risks as prescribed by regulations.
So now you would fall under the Proceeds of Crime Act 2018. If they can see that you participated in any one of these offenses, corruption, cybercrime, human trafficking, money laundering, or financing of the proliferation of weapons of mass destruction, terrorism, or financing of terrorism,
Mhm.
and such other risks that may be prescribed by the regulations. So we know money laundering and Proceeds of Crime Act would now be interrelated, eh?
Right.
Okay, let's go.
Part 2 of POCA, Proceeds of Crime Act, outlines the offenses identified as money laundering. Section 9, concealing. A person commits an offense of money laundering if acting with knowledge or reasonable suspicion A, conceals the proceeds of any crime. B, disguises the proceeds of any crime. C, converts the proceeds of any crime. D, transfers the proceeds of any crime. E, removes the proceeds of any crime from the Bahamas. Section 10, arrangements concerning proceeds of crime. An offense is committed of money laundering if the person knows, suspects, or ought to reasonably have known or suspected that he has entered or is entering into an arrangement with which facilitates, by whatever means, the acquisition, retention, use, concealment, or the control of proceeds of crime by or on behalf of another person. Section 11, acquisition, use, and possession of the proceeds of crime. An offense of money laundering is committed where a person knows or suspects or ought to reasonably have known or suspected that he acquired or is acquiring the proceeds of crime, used or is using the proceeds of crime, or possessed or possesses the proceeds of crime. The three ancillary offenses under POCA are Section 12, failure to disclose. An offense is committed under this section if each of the following conditions are satisfied: failing to disclose to the Financial Intelligence Unit or to a police officer that one knows, suspects, or reasonably ought to have known or suspected that another person is engaged in money laundering or committing an offense related to an identified risk, that the information or other matter on which his knowledge or suspicion is based, or which gives reasonable grounds for such knowledge or suspicion came to him in the course of his business, that one does not make the required disclosure as soon as is practicable after the information or other matter comes to the person. Section 13, failure to disclose by the MLRO. An offense is committed where the MLRO knows or suspects or has reasonable grounds for knowing or suspecting that another person is engaged in money laundering or an identified risk activity. Any information from an alleged offender on which the knowledge or suspicion of the MLRO is based or which gives reasonable grounds for such knowledge or suspicion, and the MLRO does not make the required disclosure as soon as is practicable after the information or other matter comes to him. Section 14, tipping off. An offense is committed if one knows or suspects that any disclosure under the Part 2 of POCA have been made, or an action has been taken by the FIU in relation to anything under Part 2 of POCA, and one makes a disclosure to another person which is likely to prejudice any investigation which might be conducted following the disclosure made.
Okay, so we have the primary offenses. And these are the ancillary offenses that will occur as a result of the primary offenses being concealing arrangements concerning proceeds of crime and acquisition, use, and possession of the proceeds of crime. So who would be the offender in the first three instances, not section 9, 10, and 11?
Suppose the company or someone related to the company.
Right, and then the ancillary offenses would now be what? Who would
The
cause that?
financial corporate
Right.
service provider.
Right. So you would now be charged under the ancillary offenses for facilitating the major offenses, yes? Because now you would not only be charged with the major one, you'd be charged with the ancillary one, because you would have now concealed, and then you would fail to disclose. You fail to disclose by the MLRO, you fail to tip off, all of that. So you see how much offenses they could charge you with?
Hi,
Okay.
Ms. Gossett.
Uh-huh.
can you clarify again who would be responsible for each of the offenses?
Okay,
You said
so,
the primary would be the company.
right, so the primary is now your client who would have concealed. They would have arranged concerning proceeds of crime, and they would have acquired, used, and possessed the proceeds of crime. But now you as the company, the MLRO, you are aware that they're doing this, and you fail to disclose that, eh? So you have committed the ancillary offense. But you would also be charged with the major offense, eh? Because you knew this was happening, so you would have also concealed, eh?
Okay,
See, the client wouldn't be the person who is the MLRO, eh?
no, ma'am.
Right,
It'll be someone
So-
in the company.
okay. So you fail to disclose that you know somebody is doing this.
Ms. Darcy, could the corporate service provider also be charged with, in terms of arrangement, since it says that facilitate entering into an agreement which facilitates, like if
Right, so
they're
that's what I'm
helping?
saying to you. You
Okay.
won't be charged with only the ancillary offense. You'd be charged with the major offenses as well. See, because you facilitated, but then you would have had to do it as well, eh? You didn't you caused everything to happen. And you did that in addition to not doing what you're supposed to do as a, what? Person who know or ought to have known, eh?
Yes. It's a prudent businessman.
Yeah, that one. So now you see, your client may not even be charged with as much offenses as you. So you have to be careful of, you have to take all necessary precautions to ensure that you don't implicate yourself into these matters. Now, you don't want to just throw up red flags every minute, because then you won't have any clients, eh? You have to ensure that you're doing what you're supposed to do, ask the right questions, and then if you feel comfortable enough and you've done your due diligence. Now, if you have done all you were supposed to do, and you can show that you've done it, they can't, if they now discover this person is actually a money launderer, but you have done what you were supposed to do, and you can show it, and you can prove it, you won't be charged, yes?
Yes.
Because you would have done what you were supposed to do. You followed your procedures, you ensured this was not, if they were able to conceal and present you with fraudulent documents even after you would have checked, or they were doing things that you would have no control of or no way of knowing because of what they presented to you, then you can't be charged because you didn't facilitate it. You did what you were supposed to do. Okay? Everyone is clear on that?
Yes,
Yeah.
ma'am.
Okay, so we have Proceeds of Crime Act 2018, and we know what the offenses are. 9, 10, 11, and then we have ancillary offenses, 12, 13, and 14. Okay, who's gonna continue reading for us?
The legal requirements for customer due diligence. The Financial Transactions Reporting Act 2018, FTRA, outlines the customer due diligence measures and the Financial Transactions Reporting Regulations 2018, FTRR, outlines the customer due diligence requirements under Bahamian law. Individuals, entities, trusts, and other legal arrangements, and partnerships or unincorporated business for the acceptance of business. Pursuant to the FTRA, it is mandatory that financial institutions conduct a risk assessment to identify, assess, and understand its identified risks related to its clients and countries, jurisdictions of their origin, countries, jurisdictions of operations, and products, services, transactions, and delivery channels. The FTRA Section 7 mandates that financial institutions identify the identity of a facility holder by means of verifying reliable independent source documents, data, or information. Identify and verify the identity of any person purporting to act on behalf of a facility holder and verify that such person is properly authorized to act in that capacity. Understand as appropriate, obtain information on the purpose and intended nature of the business relationship, including the ownership and control structure of the facility holder. Identify and verify the beneficial owner of a facility, and if corporate, beneficial owners of 10% or more controlling interest. The FTRR states the mandatory documents required by financial institutions to verify the existence of a facility holder. Simplified due diligence is conducted on facility holder identified as low risk, unless there is a suspicion of activities related to an identified risk in which enhanced due diligence is required.
Okay, so this KYC outline, eh?
Yes,
This is what the financial institutions should now require of their facility holders. They have to identify and verify the identity of any person who is now the facility holder, and how they would do that. By what?
Roja?
Independent source documents. What is an independent source document? Because it can't be from the person, eh? We need somebody independently to verify that they are who they are. How would that be done? Just a basic question.
Would that be something similar to having notarized or certified ID or address document?
So, right, so your ID would be sufficient, eh? And that would be done through a government issued ID. That's an independent source, eh?
Yes.
And so if you don't bring me the original, then you have to get it notarized that it's a true copy of the original by an attorney, eh?
So it only
What
have to be notarized for copy.
Only if you bring me a copy, I would need you to notarize. If you bring me the original, I can copy it because I can verify that that was the original I received, eh?
Okay.
Yes. So if you don't, and some banks may say, no, you better bring me the original, I'd rather copy it. Now, what about the person acting on behalf of the facility holder? We need that information for them?
Yes, as well as like in the case of a power of attorney, an actual power of attorney document to verify.
Showing that they
that.
authorized to act in that capacity. And then what we need to know, the nature of the business relationship, ownership and control structure of the facility holder. And then where there's a corporate, in the corporate instance where they're beneficial owners who have 10% or more controlling interest, we have to verify the beneficial owners there too, eh? So in this instance, this is where we would stop when it's a low risk. What may be low risk? Where your source of wealth is from where?
Maybe if your source of wealth is from a business that's regulated.
right? Or you have just salaried income. So this is an easy one. We could just say, well, yeah, this could play because your salaries, your work letter says you make 100,000 a year. Your account, you already said, won't go over 60,000 a year. You wouldn't transact more business than that. You may be invested in the stocks and shares market. And you anticipate based on previous returns, you won't be generating more than $60,000 a year based on your savings and income from outside investments. So they low risk. So we now go to enhanced due diligence when we're gonna now have some high risk persons, eh? Because when you're high risk, what that means?
That means you could put the company at risk.
And then what else?
Get a
happens?
higher level of screening.
Right, and why would I want to screen you more? What could be happening?
Money laundering, terrorist
The
financing.
potential for that you could be money laundering, eh?
Yes,
Why would why would I screen a political person?
because they may be more at risk because of their connections to be involved in something.
So they could now take public funds and be facilitating it through their account, eh? Because they
Yeah.
have some power to do that.
Right.
So in government agents, you would want to say they may be in a high risk category because now they only supposed to be getting 60,000 a year, but they running 300,000 through your account. How you get all this money? I have to make sure that it's not as a result of proceeds of crime, because crime could be where you take in public funds for your private interest, eh?
Yes.
Okay, so let's go to enhanced due diligence. Any questions on the legal requirements for customer due diligence so far?
No, ma'am.
Okay, let's go ahead. Now what act now outlines the due diligence measures for your customers? You all know what the act is?
Is it the Financial Transactions Reporting Act?
Yes, 2018. And what POCA is?
It's the Proceeds of Crime Act.
And what that helps us with?
To identify
The
crime-related clients.
offenses under the Proceeds of Crime Act that may happen in what? With what?
money
Uh,
laundering.
Laundering.
Money
Money laundering.
laundering, yes. So POCA, that's how it's related to us. We have some offenses under that our clients may be accused of money laundering. And how we will be interrelated or connected if we don't ensure that our clients, if we don't do our due diligence as set out under the FTRA. Okay, let's go ahead.
A financial institution is required to conduct enhanced customer due diligence to business relationship or transaction with facility holders, beneficial owners, or financial institution from a jurisdiction assessed by the IRF Identified Risk Framework Steering Committee, comprised of key government agencies, and such enhanced measures are proportionate to the risks identified. The financial institution is required to examine as far as possible the background and purpose of all complex, unusually large transactions and all unusual patterns of transactions which have no apparent economic or visible purpose. A financial institution is also required to mitigate against the risks identified with respect of facility holders, beneficial owners, or financial institutions assessed as high risk. Politically exposed persons. A financial is required to have in place appropriate risk management systems to determine whether a facility holder or beneficial owner is a politically exposed person or PEP. This identification of a PEP, PEP, should be made prior to establishing or continuing a business relationship with such facility holder or beneficial owner. The approval of senior management must also be obtained. The financial institution must also identify the source of wealth and source of the funds of the facility holder and conduct enhanced ongoing monitoring of the business relationship. PEP has been defined by the Basel Committee on Banking Supervision's paper, Customer Due Diligence, as individuals who are or have been entrusted with prominent public functions, including heads of state or of government, senior politicians, senior government, judicial or military officials, senior executives of publicly owned corporations, and important political party officials. The Basel Committee definition also extends to an official's family, close associates, and to any business, incorporated or unincorporated, with which the official has a relationship. As far as KYC, knowing whether or not a client is a PEP is an essential element of customer due diligence and risk rating. Example, PEPs are considered high risk. A financial institution should consider the following KYC information in mitigating PEP risk once it has decided to accept the PEP client. 1, the geography. 2, source of wealth. 3, source of funds. 4, commercial rationale for the arrangement of relationship.
So automatically, PEPs come under high risk because they are defined as persons who have been entrusted with prominent public functions. So they have a lot of influence, eh? They include heads of state or of government, senior politicians, government, judicial or military officials, executives of publicly owned corporations, and important political party officials. So you think the judiciary will come under a high risk? If a judge comes to open an account, do you think they'd be high risk?
Yes.
Yes, because they have a lot of influence, eh?
Yes.
If they come in with some big deposits, what you could say that's a red flag, eh?
Yes.
Because what they may be doing,
Money laundering.
they're making decisions in the court and getting paid, eh?
Bribery.
Bribery.
Yes, so you have to look at all those things. So you would be able to carefully and closely identify who are low risk and who are high risk based on their positions, eh? Because you would consider certain people in certain positions to be high risk, because you'll say, now you have a lot of access to get at monies that really won't be yours. So I have to watch you carefully, eh? And you would have to do what? What they say you have to do when you already have identified them, what you have to do?
When you've already identified the person.
Right, the PEP, their source of wealth and the source of funds, what you have to do, conduct what?
A raw.
You have to conduct enhanced ongoing monitoring of the business relationship. So you just can't do it once. You have to constantly be monitoring how they operate their accounts. Because as long as they have that influence and they're in that position, you have to make sure that they stay within the guidelines, eh? And any sudden deposits or sudden wealth, you would have to question, because now you may be facilitating money laundering, right? Okay?
Okay.
We have any questions? Are we clear?
Claire,
Okay. All right, so who's gonna
I have
read?
a question,
Okay, go
Miss
ahead.
Fawcett. Okay, in terms of when it comes to the world check, do you think a world check is enough? Do you think that platform is in depth to really, well, more so accurate to really give you a good report on an individual?
Well, I mean, I don't know that it applies in the Bahamas as much. It may apply outside, but we know for sure that we're not that interlinked, eh? Because you can't pull up information on me just by word check, eh?
Well, I tried my mommy.
And what
And
happened?
it brought up, well, her relation because she works to a law firm.
Mhm.
But it was weird that it had her as a pet.
Because she
So I
worked
don't
in,
know.
they have her as a pep because she works in a law firm,
I guess.
I guess. If they've, well, I mean, basically, that's what I'm saying to you. They won't have, we don't have ourselves online, more or less. The Bahamas is not that savvy yet, or they don't want to be that savvy.
Okay.
Put things out there like that. I don't know that you could just access information like, you could go online and find out where someone lives and this thing and the next. If I don't go on Facebook and put my information out there, you won't find out much things about me, eh?
Yeah, that's true.
You see, so it's up to you as an individual to put that out there, but it's not gonna be where we have systems here like BPL will say, well, Denise Dawson lives on Nassau Street. And then you could pull that up. So agencies are not really talking to agencies because BPL don't come to you and say, you still working here? Because when you opened the account, you was working there. They don't come to you afterward to ask you to update your information, eh?
No.
You don't have that. You don't have that constant ongoing where they want to monitor how you operate, and the only way they know where you living is because they could come and turn off your light. So that would be the only place who could really verify someone's address. And if I'm the only person the light bill is in the name of, and I have 10 other people living in a house and they don't pay any utility bills, everything is in my name, how would you verify that they live there? You see? So there's no way unless somebody is keeping abreast, because the banks try to do it because they want you to verify that you still live at the same place. But if I'm constantly saying I'm living in my mom's house and she could send a letter saying, yeah, he lives with me, that's all the bank requires, eh? But I may not even be living there. I live with my girlfriend or my boyfriend or my friends down the road. I don't pay, I just share an apartment with them. So there's no real checks you can do, I think, here in the Bahamas unless the person is putting that information on there. Because the banks here don't share information, we pride ourselves on what?
Confidentiality.
Yes, so what word checks you could do here?
Well, I know one thing we do, we search Google to see if anything comes up, things like scandal, newspaper clippings and stuff.
Right.
We add to the file as well.
Now that's what could help. You may find that.
Yeah.
You may find something of that nature because the newspapers are now online. Before you wouldn't even have gotten that aid because they weren't even online. So, we just coming into this age where they could go into the computer and pull up some things. But now, as for my source of funds, I may own 15 buildings over here and you don't even know that. Because there's no way for you to verify that unless my name is on the buildings. And I may have them in company names. And I'm not even a shareholder. I may have it as somebody in trust for my children. Yes? Because there's no way, and only when you get to real property, they may say, well, who's the ultimate beneficial owner? And I'll say, well, the ultimate beneficial owner is my child who's 5. It's in trust for them. It's not really mine. I'm just holding it as a trustee. But I have control, eh? So I could divest myself of everything I own. Yes?
Yes.
Any questions?
Yes, I have a question. So
Mhm.
in terms of when you're collecting, like maybe, I guess onboarding, or even when you're doing a file update for a client, is it then sufficient in the eyes of the court if you ask the client to disclose where their money is coming from, businesses that they're involved with, their value of assets maybe, and then they sign a disclaimer to say that they've given everything to
Right,
you? Does that now turn liability off of the company and onto the client in the
Yeah,
case of
because
something being hidden?
right, and then you would have done your checks. So you would,
Okay.
so even if you had done a Google search, you would print that search to say this, I didn't see anything. So you could put all this on your file. Because you
Okay.
want to prove that you've done your part. If I
Okay.
did like the world check, I'll print that to say I didn't see his name. You have to print these things because you have to show you did it, eh?
Yeah.
And so once you've done your part, see, that's how you'd prove yourself to have done what you were supposed to do. You have to prove it through saying you've done these things in addition to what the client. So not only did the client tell me this, I went behind and checked everything out. So if they say they banking at so-and-so bank in Switzerland, I went on the internet and I saw if that bank was existing and I printed it and I saw that who signed it is actually an officer in that bank. You see, because when you
Okay.
get the letter from the bank, it's gonna, somebody high up had to have signed, eh? And usually these banks will have their management team on their website.
Okay. Thank you.
Yeah, so you have to do a little bit more. You just can't take it on the face of it. So sometimes you say, okay, this bank, they don't have much information on there. I better give them a call and ask to speak to so-and-so. And then that would show that I made a call at this thing at this number. So-and-so answered and I spoke with so-and-so, and that's that. Just as extra form when you have some doubts, yes?
Yes. Thank you.
Okay. Let's continue.
Okay, internal reporting procedures and training. Regulation 5 of the Financial Intelligence Transactions Reporting Regulations 2001, FITRR, requires financial institutions to institute and maintain internal reporting procedures, which include the following: identification and appointment of a money laundering reporting officer, MLRO, who should be registered with the FIU or Central Bank of the Bahamas, and to whom a report is to be made of any comes to the attention of an employee, and such, in the opinion of that employee, give rise to a knowledge or suspicion that another person is engaged in money laundering. Regulation 6 requires that a financial institution take appropriate measures from time to time to ensure that all relevant employees are trained and made aware of the provisions of the Financial Intelligence Unit Act 2000, the Financial Transactions Reporting Act 2000, the Financial Aid and Corporate Service Providers Act 2000, the Proceeds of Crime Act 2018, the Financial Intelligence Transaction Reporting Regulations 2001, and any other statutory provision relating to money laundering. The procedures maintained by the institution in compliance with the duties imposed under these regulations. The financial institution must provide all relevant employees from time to time, at least once a year, with appropriate training in the recognition and handling of transactions carried out by and on behalf of any person who is or appears to be engaged in money laundering.
So once you are now a financial institution, you should have a money laundering training session once a year. You have that in your organizations, right?
Yeah.
Because
Yes.
everybody has to sign off to say they attended and so forth and so on. That goes
Yeah.
over these regulations once a year, just as a matter of course. And as a part of what they have to do as a part of being a financial and financial corporate service provider or financial institution as a whole. You have to do that training to ensure that everybody is up to date and they know what their role is, because everybody has a role to play. Eh? Because what is one of the ancillary offenses? What, as a person who may not be directly involved, but you are working at the financial institution, what you could do?
Failure to report.
You could tip off, eh? If you
Yes.
tip, you could just be a tipster. Where you're not directly involved, yes? So they would have to bring all this to your attention, because then they'll say you were working there, you had to have seen something, and then you say, I did, but that wasn't my place. But then if you had the training, you would know that you were mandated in accordance with the what to do so. You were mandated in accordance with what?
The act.
The
Proceed with
POCA,
that.
right?
Yeah.
Mhm. Okay, let's go ahead.
Okay, know your client or customer due diligence. KYC is an acronym to know your client. Know your client information is information that is obtained and used by an organization to verify a client's identification, gather information about his business, assesses and rate the potential risk that the client may present to the organization, and make a business decision on whether or not to accept the client and his business. CDD is the acronym for customer due diligence. Customer due diligence is additional and/or detailed information that is obtained from a client by an organization in order to update a client's information other than the original KYC information on acceptance. Further assesses the potential risk that a client possesses to the organization, monitor client activity, and mitigate or manage client risk. It is important for a financial institution or financial and corporate service provider to establish KYC policies and procedures as part of its due diligence process in order to effectively and thoroughly vet prospective clients and consistently monitor existing clients, particularly those for whom it provides corporate, financial, and fiduciary services. The FTRA Section 12 makes it mandatory for financial institutions to exercise risk based on ongoing due diligence throughout the course of each business relationship, which includes the following: ensuring that documents, data, information, and records collected are kept updated and relevant, and undertaking regular reviews of existing records, particularly high-risk facility holders. Scrutinizing transactions to ensure that the transactions are consistent with the financial institution's knowledge of the customer, the facility holder's risk profile, and the source of funds where necessary. Ensuring the obligations with regard to high-risk facility holders, politically exposed persons are fulfilled at all times.
Okay, so we have this instance where the banks now ask us to update our information, eh? When you get to the bank, sometimes I know Commonwealth Bank does it, they would freeze your account if you don't update it every year, right? they ask you for updates. Make sure your address is the same. Reviewing the account. So you have that, you've encountered that in your workplace, you've done that?
Yes.
Because you're supposed to do it annually, more or less, to keep yourself updated, or even if you do it, I think you need to do it annually, because people could change addresses from year to year. They could change jobs, their positions may be, their financial positions may change. So you should just do a quick checklist and ask them just to verify it. Yes? Then you have to scrutinize the transaction to ensure that they're consistent with the knowledge of your customer. So if your customer said, I'm only gonna be transferring about 5 to 10,000 a month, and now over the period of time, you realize if they've been doing a lot more, you now have to pull them in and rate them and ask them what's going on, eh? Because this is not what we agreed to. And then you have to ensure that the obligations you have with regard to high-risk facility holders are fulfilled at all times. And how would you do that? Through your due diligence processes, eh? Going over to ensure that everybody stays within the guidelines and there are no red flags as to deposits being made. Okay, let's continue.
Okay, one of the primary objectives is to ensure that a financial institution's clients are of a good reputation and character, and their business activities are lawful within the ambit of the existing laws of the Commonwealth of the Bahamas and international best practices as it relates to anti-money laundering, customer due diligence, and corporate governance. Whenever a person conducts or seeks to conduct any transaction through or with a financial institution, whether or not the transaction or proposed transaction involves cash, and the financial institution knows, suspects, or has reasonable grounds to suspect that a transaction or proposed transaction involves the proceeds of criminal conduct or offense. 2 is an attempt to avoid the enforcement of POCA, or is an identified risk. It is mandatory that a financial institution report the transaction or proposed transaction as soon as practical to the FIU, Section 25 of the FTRA. A suspicious transaction report, STR, is a written report which sets out and contains the grounds for which a financial institution holds a suspicion about a particular client and or the transaction or series of transactions that may involve the proceeds of criminal conduct or an offense under specific legislation which criminalizes money laundering, that is, proceeds of crime act. Failure to make an STR will result in criminal liability in the form of fines or imprisonment for the MLRO and or the financial institution as applicable. Section 15(2) of POCA. A person commits an offense if they fail to disclose in their capacity as an individual, firm, or sole practitioner, acting in the capacity as an accountant, audit, taxation advice or services, legal or notarial services, or as the MLRO, following the satisfaction of the 3 conditions, are liable on summary conviction to imprisonment for a term not exceeding 12 years, or to a fine not exceeding 500,000, or to both on conviction or indictment, to imprisonment for a term not exceeding 20 years, or to a fine, or to both.
Okay, so if I'm preparing a suspicious transaction report, do I tell the client I suspect their transaction to be proceeds of crime?
No.
No, that's tipping
But-
off.
Okay, that's right. So that's tipping off, yes? So when I do this, I have not indicated anything to the client. I send it to the FDRA and they will do their conduct what they need to do and get back to us, eh? Yes?
Yeah.
Yes.
All right, so if I don't, what happens?
That could be
Or jail time.
jail time to
Okay,
yourself as well as the institution.
so I could go to jail
Mhm.
for a term not exceeding 12 years, or I may have to pay a fine of 500,000, not exceeding that. Or I could do both on indictment.
Yes,
to a
you can.
person. Yes, so you don't want to be a part of that, eh? Just for coming to work. So you have to do it as soon as it's practicable. You have to now report it to the FIUA under section 25 of the FTRA. Okay, let's continue. And then
Okay.
somebody else will take over after you. I appreciate it.
Okay. Section 25 sets out the requirements must be followed to submit a STR to the FIU. The STR must be in the prescribed for contain the ACE, to contain
Okay.
a statement
Must be in the
of-
prescribed form and contain a statement on the grounds.
on which the
Mhm.
financial institution holds the suspicion and contain the following information as set out in the first schedule of the FTRA.
So now I show
Which-
you how you should set out your suspicious report, transaction report. Okay,
Okay, which would be through the name, address, date of birth, and occupation of each person conducting the transaction. The name, address, date of birth, and occupation of any person on whose behalf the transaction is conducted. Where an account with a financial institution is involved in the transaction, the type and in the identifying number of the account, the name of the person in whose name the account is operated, the name of the signatories to the account, the nature of the transaction, the amount involved in the transaction, the type of currency involved in the transaction, the date of the transaction, the name of the officer, employee, or agent of that financial institution who handled the transaction, the name of the person who prepared the report.
so this is how your report would be set up. You would put in that information. And then you would say, what is the, what you're gonna say? What they said you have to put in there.
A statement on the grounds holding the suspicion.
Yes, on which you hold a suspicion, and then you would put this information in there. Okay? Any questions? So you see, if you want to fill out a STR, you don't even need to go far. We have this, the line, it's set out in the act. First schedule of the FTRA, but if you don't, you could come right back to your book and type it up, eh? So there's a precedent you could put in your money laundering manual if you didn't have it there already.
Now, only the MLRO will be the person preparing this?
Yeah, the MLRO would be the person who has to do that, because you as the employee will go to the MLRO and it's their duty to do it, eh? Because they have an offense just for them, eh? Just remember, that's an ancillary offense.
Yes.
Mhm.
Wouldn't you still be providing them, I guess, with the information on what you have encountered that makes you feel like it needs to be reported?
So you would go to the MLRO with your information, and they are now the person who would have to fill this information out and send it on to the FIU. Now, if you feel like they have not done it, you can try to approach them yourself, eh?
approach the FIU yourself?
Right, because what you're saying is, listen, I approached my money laundering reporting officer. I don't know. This has been some 6 months and this is constantly going on. And I've already spoken to them. And they've not come to you, and I don't feel comfortable continuing to work in this, or you could just stop working there. But you still would have now known about the crime and you didn't do anything about it, eh? Because you're tipping off, eh? What tipping off is?
If you give information to anybody who could possibly affect any investigation. So I guess if you tell the MLRO and they don't do anything, they could potentially be doing something in the background.
Right, so you
Right.
failed to disclose, right? You could disclose that to the Financial Intelligence Office, unit, or to a police officer.
But if you leave that company that don't absorb you, right, you can still be
No,
charged.
that's what I'm saying. You can't just,
Okay.
you know of a crime and you've not reported it.
Okay,
Because you could say, well, you know something, I reported it to the money laundering reporting officer, but I didn't follow up because I was actually leaving the company. This only came on my desk and I'd already put in my resignation, but I thought it came across my desk within the course of my 2 weeks I was supposed to leave. I gave it to the money laundry, but I'm no longer with the company. I wouldn't have known if they approached you, and it wouldn't be your place to ask that now that you've left the company. But if you were still in the company, or if you left the company because of that reason, then what that means, you knew of a crime, eh? Yes?
yes. Agreed, yes.
And now you're trying to bail out, more or less. Any questions on that?
No, ma'am.
Okay, let's go to KYC. Who's gonna start us off with that one?
I can.
Okay, so now we have a KYC form that we can now compare against our form at work to ensure we have all of this information, or we may even have additional information on our own forms. Let's go ahead.
KYC, customer due diligence best practices. The following information may be appropriate to verify client identification and access, whether to accept and or maintain a client. The full name, home, and business addresses, including telephone and facsimile numbers and email address, nationality, occupation, and date of birth of the ultimate beneficial owner of the companies, principals slash professionals companies slash principals slash professionals related to or concerned with the client. 2 reference letters from reputable law firms, accounting firm, bank, or other financial institution. The reference letters must be original letters on the letterhead of the law firm, accounting firm, or bank, etc. Indicate the nature of the relationship with the ultimate beneficial owner and principal, which should be at least 6 months old and be fairly recent, no more than 6 months to a year. No more than 6 months to a year. Copies of the relevant pages of passport of the ultimate beneficial owner slash principal, indicating and verifying the identity and relevant particulars of the person, where there is a reason to believe that the person holds dual citizenship or nationalities. The relevant pages of both passports are required. Copies of a recent utility bill or credit card statement in order to verify the client's current residence. Alternatively, copies of the identification card of the ultimate beneficial owner / principal is required. Copies of driver's licenses and other forms of identification as permissible by Bahamian law may also be accepted. Specific statement of purpose for the incorporation / establishment of the company. Name, address, and relationship of the correspondent acting on behalf of the ultimate beneficial owner / principal. Name, address, and relationship of the correspondent acting on behalf of the ultimate beneficial owner / principal. Additional requirements for US citizens. US citizens must provide some evidence that they have been advised of their legal and tax reporting requirements in the United States before establishing an offshore corporate entity, and in certain instances, provide us with an affidavit that they will continue to meet such tax reporting obligation themselves without any liability to the financial and corporate service provider for any omission or inadvertence in completing such requirements. Additional requirements for Canadian citizens. Canadian citizens must provide some evidence that they have been advised of their legal and tax reporting requirements in Canada before establishing an offshore corporate entity, and in certain instances, provide us with an affidavit that they will continue to meet such tax reporting obligations themselves without any liability to the financial and corporate service provider for any omission or inadvertence in completing such requirements. Requirements for closely and widely held companies, where the ultimate beneficial owner is a listed company listed on a recognized stock exchange, a copy of the company's annual report, Bloomberg extract, or stock exchange filing must be obtained, and a specific statement of purpose for which the company is being established is required. Where the ultimate beneficial owner is a widely held company, a company with 3 or more unrelated shareholders, none of whom have a controlling interest in the company, a copy of the prospectus, extract of the share register, written confirmation from lawyers / auditors, or an extract from Bloomberg / Reuters, and a specific statement of the purpose for which the company is being established is required. Requirement for trusts, where the beneficial owner is a trust, the full name, home and business addresses, nationalities, and occupation of the settlor, beneficiaries or class of beneficiaries are required, and the protector, if any. The name and full address of the trustees should also be obtained. Copies of passports / identity cards of the settlor and beneficiaries. Statement of purpose for which the company is being established is also required.
Okay, so we have our KYC so far, so we don't go too far. We'll have to have a utility bill or credit card statement to verify your address. The copies of the relevant pages of the ultimate beneficial owners. Verifying their particulars. If they have dual citizenship, we should have both passports, eh? We should also have financial records or records from a law firm, not more than 6 months old to a year, verifying these persons and the nature of the relationship and how and what they do. We should have their full name, home, and business addresses. We need a statement of for the purpose of incorporation or establishment of the company. That should be a part of your KYC. If there's a person acting on their behalf, on behalf of the beneficial owner, we should have their name, address, and the relationship. And where there's a US citizen, they need to give us a statement stating that they have done their part in reporting, doing their reporting in the United States for their legal and tax requirements, as well as Canadian clients. They would have to do the same thing. This is all for your benefit, so it don't come back at you, eh? Where the beneficial owner is a listed company, we need a copy of your annual report, Bloomberg extract. So to show you on the on Bloomberg, we want an extract of you on there, or the stock exchange filing, and a specific purpose stating what the company was established for. Whereas widely held company and we have 3 or more shareholders and nobody has a controlling interest, we need a copy of the prospectus to show why the company was established, what it's intending to do. An extract of the share register, which will show us who would the extract will show us from the share register. What that extract will show us.
Shareholders, huh?
Yes, to show us the shareholders. A written confirmation again from the lawyers or accountant. The extract from Bloomberg and the statement for which the company is being established. Again, we talk about the requirements for the trust. And we talked about this earlier. We want to know the full name, home and business addresses, nationalities and occupation of the settlor. The beneficiaries or class of beneficiaries are required, and the protective any. We need all that information on each one. You open an account, so we need to know the full name and address of the trustee. And then we need the identity cards of the settlor and the beneficiary and the statement again for which the trust is being established in this instance, not the company, okay? Any questions? Your form usually has all this information in it.
Yes.
Good stuff. Okay, let's continue.
Eligible introducers. Where a correspondent intermediary or eligible introducer, example, bank, law firm, financial institution, fiduciaries, etc., introduces a client to the firm, there should be some independent verification of the correspondent/intermediary to ensure that it is in good standing within respective jurisdiction and professions, and that it can be reasonably relied upon to have conducted its own due diligence screening of the client. Where necessary, a written verification of the due diligence screening and approval of the reputation and character of the client should be obtained and should be in accordance with the standard Know Your Client policies and procedures.
So the law firm or the bank or financial institution or fiduciary may be an eligible introducer. And in that instance, we may need some form to show that they're in good standing in their profession and their business. So you may have to provide us with some certificate of good standing or probably your license to show you are actually authorized to conduct business. Yes, and then we may also ask for a written verification of your due diligence, screening and approval of the reputation and character of the client. So we may ask you for some confirmation that you've done your due diligence and KYC procedures to ensure the client is in good standing.
So in that case, I'm not doing KYC, I'm going on the introducers KYC.
No, you want, see, that's an extra layer because now you've been introduced through the law firm. You're relying on what they have done and then you're gonna do your own. You still have to do your own, but you have that as, that's like you went on Google check. You made sure that this client was introduced, so you not only did your part, you also found out who introduced them has done their part too.
Okay.
Okay? Let's continue.
Provision of nominee and authorized signatory services. Whether financial and corporate service providers providing a nominee shareholder to a company or holding shares under a declaration of trust, the relevant nominee agreement or declaration of trust document must be completed, agreed, and executed by all parties. The identification of the ultimate beneficial owner must be known, verified and approved, and information provided to the firm as required above. Read passports, reference letters, etc. Whether financial and corporate service providers given signing authority or any authorization thereof with regard to its position as a director or authorized signatory, the client must complete a declaration of source of funds. Provide us with all information required in the foregoing paragraphs relating to nominee services and certified copies of the relevant pages of his or her passport. A management agreement for corporate director services, fee agreement for client services generally, and a service agreement for corporate services generally must be accepted, completed, and executed by the financial and corporate service provider and the potential client before the dispatch of the corporate documents. Any further documents for failure to comply. And in certain instances, such agreements should be agreed and signed before undertaking or initiating work on the client's behalf. An internal legal and compliance audit will be conducted on all clients' files on a quarterly and or semi-annual basis, notwithstanding the necessary or compulsory by law to do before such time, and on a more consistent basis in order to ensure that all clients have met the financial and corporate service providers know your client requirements and any statutory requirement that may be in existence at the time.
So where you have the provision of nominee and authorized signatory services, we'd have to make sure that those who are providing the nominee shareholder services, they provide us with the agreement, the nominee agreement or the declaration of trust document. And it must be completed, agreed, and executed by all parties. The identification of the ultimate beneficial owner should also be known, verified, and approved, and information provided to the firm as required below above. That's passports, reference letters, etc. is in place. Whether financial and corporate service providers given signing authority or authorization as a director or authorized signatory, the client must complete a declaration of the source of funds and provide all information as required. That's the passports, all that stuff. The management agreement should be in place for corporate director services providers, the fee agreement for services and the service agreement for corporate services must be accepted, completed, and executed by the FCSP and potential client before dispatch of the corporate documents. Now, all of these things would be done where y'all would have read this before, when y'all had to do what? In unit what? Remember in unit 3, the company and corporation, you had some checklists?
Yes, for onboarding to know
Right,
what
so
everything
this
is about.
was post incorporation, right? We had to reserve the company name, prepare memo and arts. This was on in your unit 3. This now expansion of what you had to do in unit 3 when you were incorporating the company. Because one was to prepare the management and our nominee agreement as applicable, and that's your management and nominee agreement. Where you had to, you had eligible introducers, you had that as well in your requirements for incorporations, which you had to do with the eligible introducers. We had all that in our checklist. So when you go over unit 3, you would see that this is an expansion of what you had to do in unit 3, okay? Then you'd have to have an internal legal and compliance audit on your client's files on a quarterly or semi-annual basis. And this is notwithstanding the compulsion by law, necessity or compulsion by law to do so before such time or on a more consistent basis. This is to ensure that your clients have met your financial and corporate services providers, know your client requirements and any statutory requirements that may be in existence at the time. So once these things are flowing and you are in good standing, you're doing, because this will keep you on top of what you have to do if you're doing this on a consistent basis. So you should have files that you are in charge of, and you have to do your checks every so often. So you should have a diary in place to know what you have to do next. What is how you should have your files in order to say, or this is my quarterly check, or this is my semi-annual check on these files. And if anything is missing, I'll send out to the client now, and then you'll follow up to make sure they respond to you accordingly. Make sure all these agreements in place where you're acting as nominee, director, and so forth, and you have your nominee agreements in place, your fee schedule in place, and so forth. Any questions?
None from me.
Good? We good on this?
Yes, ma'am.
Okay, so let's answer our questions. Define money laundering, where we'll find that answer.
Page 59.
And what is money laundering?
The process by which criminals attempt to conceal the true origin and ownership of the proceeds of their criminal activities.
Excellent. What are the 3 stages of money laundering? Where we'll find that answer.
Page 59 as well.
And that is?
Placement, layering, and integration.
Excellent. What are the 3 primary money laundering offenses under the Proceeds of Crime Act 2018? Where we'll find that answer.
On page 60.
And what is that?
Concealing,
Mm-hmm.
arrangements concerning the proceeds, and acquisition, use, and possession of the proceeds.
Okay, and what are the 3 ancillary offenses under POCA? We will find that answer.
1661.
And what that is?
Failure to disclose, and then failure to disclose by the MLRO and tipping off.
Excellent. And what sections? Y'all didn't give me the sections of the POCA. That section what?
9, 10, 11, 12,
Well,
13, and 14.
Excellent. Number 5, blank mandates that financial institutions as defined in section 3 of the Act verify the identity of their customers who wish to become facility holders, existing facility holders whose identities are doubtful, existing facility holders, and those with occasional transactions. Where we will find that answer.
So is it supposed to be section 3 of the Act or section 7 of the Act?
Okay, we have that underlined, so FTRE. Section 7.
Okay. So yeah, page 61 and 62.
Okay, and what's that?
That is mandating that you identify
And who's that?
the financial institution does the identifying and verifying facility holders.
No, tell me what mandates financial institution, what that is?
Oh, the financial transactions reporting act.
Right, Financial Transaction Reporting Act 2018. Okay, number 6, define KYC, where we'll find that answer.
That's on page 64.
And what is that?
KYC is the acronym for Know Your Client. And that's where you verify the client's identification and gather information about their businesses and other potential risks.
For your client, so it's
Client.
so it's the information that is obtained and used by an organization to verify a client's identification, gather information about his business, assess and rate the potential risks that the client may present to the organization, and make a business decision on whether or not to accept the client and his business. Yes?
Yeah.
Okay, and what is CDD? Define.
Customer to.
Where we'll find the
diligence.
answer first.
On page 64,
Okay, and what is that?
the acronym for customer due diligence, and it's an additional detail of information that is obtained from a client by an organization to update the client's information other than the original KYC information. And it assesses the potential risks that a client possesses to the organization, and you use it to monitor client activity and mitigate and manage clients' risk also.
Excellent. Now, how would we define an STR? What is that? Where we'd find that answer?
Page 65,
Excellent. What is that?
a written report setting out and
What
containing
is
the ground.
STR first? Tell
Oh,
me.
sorry, a suspicious transaction report
Right,
is a written report setting out and containing the grounds for which a financial institution holds a suspicion about a particular client and or transaction or series of transactions that may involve proceeds of criminal conduct or an offense under a specific legislation criminalizing money laundering, like the Proceeds of Crime Act.
excellent. Everyone has that? Number 9, what is the penalty for failing to report an STR? Where we'll find that answer?
Page 65 as well.
And what is that?
For the summary conviction, you can be imprisonment for a term not exceeding 12 years or a fine not exceeding 500,000 or both.
And where we'll find that penalty? Under what?
Oh, the Proceeds of Crime Act,
What section?
section 15.
Yes, 15(2)(8).
15(2).
So we'll find that penalty under 15(2) of the Proceeds of Crime Act, and the penalty is imprisonment for a term not exceeding 12 years, or fine not exceeding 500,000 or both, on a conviction or indictment, to imprisonment for a term not exceeding 20 years, or to a fine, or both. What are the best practices for client due diligence for individuals and for trusts? What are the best? Where we'll find that answer? That is covered on what?
On
On page
page 67.
67.
To
Just from 66, 67.
67 to where? For both.
68.
Okay. And that includes all our know your customer, due diligence, best practices. We need the full name, reference letters, relevant pages of the passport, recent utility bill or credit card statement, copies of identification cards of ultimate beneficial owner, driver's license, or other forms of identification permissible by Bahamian law, specific statement for the purpose of incorporation or establishment of a company, name and address, and relationship of the correspondent acting on behalf of the ultimate beneficial owner, and relationship of the correspondent acting on behalf of the ultimate beneficial owner. Where we have US citizens, what we need?
Evidence that they've been advised of legal and tax reporting.
Right, and what about Canadians?
Same thing,
Same.
evidence.
Okay, and what if we have closely or widely held companies that are the beneficial, ultimate beneficial owner? What we need?
A copy of their annual report, Bloomberg extract, or stock exchange filing.
And statement for the purpose
Yeah.
that is being established. Same thing with the widely held companies, eh? We
Mhm.
may need the prospectus and an extract of the share register in that instance again, right?
Right.
With the trust, would we need?
Information, the full name, home and business address, nationalities, occupation of the settler, beneficiaries or class of beneficiaries, and also information on the protector, if there's any.
Excellent. What else we may need?
Trustee,
Copies-
the trustee name and full address and copies of passport identity cards of the settler and beneficiaries, and why the company is being established.
So the trust in this instance, eh? The trust is being established. That should be trust in that instance.
Okay.
So we have any questions on what money laundering is? What our role is to play as in the financial institution, what we have to do in order to avoid our clients participating in us, assisting them and participating in money laundering. Our best practices. We have any questions? We know what we're supposed to do?
I think so, no questions.
We know the laws would help us with these, give me one of the laws that we may need to look at.
Financial transaction reporting.
Uh-huh. Anything else?
Proceeds of crime.
Excellent. Mhm. And we need to constantly be monitoring the ongoing relationship with our clients, eh? Do you have any penalties for failing to do anything?
Imprisonment not exceeding 12 years.
Okay. We know what an STR is.
Suspicious transaction report.
Or
We know what a CDD is.
Customer due
customer
diligence.
due diligence.
And we know what KYC is.
Know your customer.
Notify.
Who is the MLRO?
Money laundering
Money
reporting.
laundering
officer.
reporting officer.
And should they do anything in the organization with the employees?
Train them.
Training.
Train them in accordance with what?
A bunch of stuff. The Financial Transaction Reporting Act, the POCA,
What, and what section gives them guidance on what they have to do? Regulation 6 of what?
the Financial Intelligence Transactions Reporting Regulation.
Awesome. Awesome. I think we had, these were pretty academic, these 2 chapters we did, eh?
Yes.
So, this was a big one. So we have any questions on this?
No, ma'am, I don't have any.
Okay, So we clear as day or mud on these ones.
As they,
Excellent, excellent. So in unit 7, we have company compliance. That's a short unit for your Thursday evening run. And of course, our Saturday one would be a little more involved, eh? So we could do a quick read over of those and then we'll be ready to go through it quickly on Thursday without you having any long drawn out session on Thursday evening when you want to get back home. Yes?
yes,
Yeah, sounds
So
good.
we'll continue online on Thursday. If you have any questions, you can let me know. But everybody seems to be clear. Was the chapters helpful?
Yes.
Excellent. Okay, so I will talk to you again on Thursday, God's willing, okay?
Yes, ma'am.
All
Thank
right,
you.
have a good one.
You too now. Do
Bye,
well.
everyone.
Bye-bye.
good afternoon.
Good
Okay.
afternoon.